Okay, now I'm going to acknowledge something. I understand that there is a alternative process at work at this point in time, and that what has happened is somebody has seized my YouTube account with an understanding that in the next couple of days some very serious benchmarks come up in terms of what I had done this time last year and what I was reporting on. And they've seized it for 7 days under some false claim that there is a medical misinformation. And I submitted the appeal, and they just said that the appeal terms of the appeal didn't really matter. They haven't made a decision. They haven't done anything to address the fact that it was completely unfounded for them to seize the account. And I know what this is. This has happened at least 3 times. And in the time frames during which it happened, I tracked my concerns that what they were doing was seizing my account to use as a loan for somebody else or something else. And once it happened during an election season, and the other time it happened while the governor of Texas was out of the country. And I tracked it. And my concerns were founded. Let's put it that way. So I understand that right now, for these 7 days, I'm supposed to jump through some hoops. And usually I get an attitude that is not adjudged by whoever it is that feels they're authorized to do these kind of things to be commensurate with what their expectations are in order for them to de-escalate the risk they've subjected numbers of people to by virtue of trying to engage these shenanigans. And I say shenanigans. So I am going to reel this in, and I'm going to start somewhere that I think is very important to be started, and I'm going to address directly what looks like is actually a process I've seen before. I have 3 articles up right now. 2 of them I believe I've read before in 2016. I believe I read 2 of them that are in the Express News, the San Antonio Express News, in November or December of 2016. And one of them, I remember specifically the points that are brought up in this article as they're presented. However, there are 2 distinctions that at the time would not have resonated or resounded as being alarming like they would now. I also recall reading this editorial that was submitted in connection with that, or a response that was submitted to that editorial. And I remember that more or less. I did not at the time remember the person who wrote this, but I remember there was a response to an editorial, and I had read both at the time. Whether or not the specific points are actually authentically accurate, or if it's ex post facto been changed because it's online, I cannot confirm. But I do know that the accusations, or rather the indications that are made in the original article, are, to the best of my recollection, what was being stated at the time I read this. The other points, again, I didn't have a context to identify them as being alarming, and I do now. But there is something else that is present here, and I've seen it before, but not here. As a matter of fact, shortly after returning from Honduras, there was a post on my Facebook when I still had it that was just like this. And what it was is it was a specific presentation of a woman and then another, and I'm looking at it right now. And this might be an authentic, legitimate picture of this person, but the kind of caricaturization and the implications of what they're doing with it is something I've seen before, right? And it fits a racialized pattern, and it fits a specifically misogynistic racialized pattern. So I do not know if this is true. I did not recall seeing information about how Judge Carmen Kelsey had been the winner of an award in 2008. Now, I will say right now online, there's information that I was the winner of an award, and I was not. Right? I have won some awards, but there's a specific award that I am online listed, or had been for several years, listed online as having won, that I never actually won. So I don't know about this. I haven't seen this before, but I'm acknowledging it because I'm looking at this picture and this has been done to me, right? And there's specifically racialized implications in it, including the fact that this portrayal of these kind of women with these ethnic archetypes is also associated with a Hispanic sounding name or a Latino sounding name, right? So I'm going to comment on these 2 articles that I've seen before and remember pretty much, but like I said, had no way to identify this particular information as being alarming until right now. In this article in the San Antonio Express News, dated for September 5th of 2014, it discusses here where information um, where it says, hold on a second, let me find. Okay. In one 2004 matter taken to the Fourth Court of Appeals, the transcript indicates Kelsey had her bailiff handcuff a defendant's parents and hold them for immigration officials after she inquired and learned they were in the country illegally. The defense lawyer in that case said immigration officials released the parents. Kelsey said she had no recollection of the case. Then there's another one. There's another situation here. Okay. The transcript states Kelsey told the officer he would have to go to the Behar County Jail to get the signature. This is a troublesome glimpse of how the court works. Now, in this one, it does not say that Kelsey denied or made any comment on this characterization of her behavior or the incident based upon a reading of the transcript. But at the time I read this originally, the elements of the implications of the transcript and what the transcript said was not an alarm. It wasn't a trigger to me. But I have, and I actually filed a motion in a case for somebody that's referenced in this article about how the transcript that was on the website that he had created, that among other things also had a number of amicus curiae from lawyers that were supporting him and that were saying things about Kelsey specifically in regards to her performance during this case, had been changed. That the transcript itself had been altered that was on the website from the one I read in its totality in November of 2016. Now, this wasn't that I did a skimming. I didn't skim that transcript. If you were, for instance, able to get a cache log for the computer I was on, you would see I read through the entire transcript. And a specific concern was this indication in this article, or rather the manner in which, and she says in this article, Kelsey said she had no recollection of the case. Now, this has two implications that are very, very profound, if this is an accurate recounting at the time. One, I am witness to and very concerned by the implications of the fact that the actual alleged official transcript that was used as the basis for at least one appeal that I was personally witness to through its duration, in the case of the attorney mentioned in here who was disbarred, was not the same transcript that was presented as the case and as the official transcript in November and December of 2016. Period. There were substantial substantive things in the transcript specifically that were different, that made a material difference in not only the charges that were part of what was alleged to be the misconduct during the trial, but also the context for evaluating the amicus curiae that were provided in support of the lawyer Bob Bennett, who was disbarred. There is a material difference in understanding what that critique of her performance is based on the transcript that was allowed to be used in the appeal that occurred in the summer of 2019 versus what had been up until December of 2016, as far as I was told and understood, the official court record concerning his appeal of his disbarment. And in the transcript available in December 2016, among the material differences was the fact that when the opposing counsel, or when the counsel for the client that was in bringing the disciplinary grievance began to list what they wanted as relief, one of the things that was said specifically had to do with continuing legal education classes in ethics. Bennett allegedly was reputed to be a scholar of legal ethics, and he himself taught CLE classes in ethics. But what was requested as part of the relief was, if I'm correct, 6 hours of CLE classes that Bennett had to take in legal ethics. That was requested as part of the relief by the attorney. What happened, though, is right after he provided the list of relief, and Judge Kelsey was attempting to recount the requested relief, Bennett got a cell phone message. She had said at the beginning of the trial, everybody turn off the cell phones. The rules of the court, as they were provided and was on the transcript, stated they had to turn their cell phones off. Bennett had not turned his cell phone off. And right as they were reading, right as the relief was being requested by the attorney for his former client, and she was in the process of restating what she understood was the relief, the cell phone went off. And when the cell phone went off, there was on the transcript, oh, I'm sorry. And then she expressed her disappointment with the fact that her rule had been violated. When the court resumed, when she began again to correspond or to talk with the opposing attorney, they left out, both the opposing attorney and the judge left out the information about the CLE classes. This was a very significant matter because, first of all, I had already by that time personally had experience with how alleged text messages or cell phones, and I have not at that time had never been in a courtroom, but in other settings that have particular kinds of resonance and have particular kinds of grounding. A cell phone message at a very pivotal time like that, which is a potential transactional event, can have very serious implications. I have since found more evidence that I believe directly indicates that that was a premeditated move. If not by Bennett himself, by somebody else who knew his cell phone was on while he was actually in the courtroom. Now, if that seems like conjecture or potentially spurious, the truth of the matter is the facts of the case were at the time her rules of the court where everybody had to turn off their cell phone. He did not turn off his cell phone. When the requested relief had been presented to her and she was recounting her understanding of what the presented relief was, his cell phone went off. Following his cell phone going off, she did not reflect on the record that she understood part of the requested relief was 6 hours of continuing legal education classes in legal ethics, and the opposing attorney did not correct her when she responded without recounting the CLE credit. And the CLE credit classes were not listed in the punishment or in the verdict that was assessed as a result of the trial. Now, that was a very significant matter. I personally spoke with Bennett about that specific event because there were a number of implications. So when she's saying she doesn't recall, this can bring up two possibilities. One, what did they alter the transcript in that trial that the reporter reviewed? Was the actual transcript that was alleged to be the official court record in 10 years later? This is a case from 2004. I'm anticipating that the author of this specific article read it sometime substantially after the 2004 trial itself. Did they alter the actual transcript in order to make it reflect as if this incident involving the bailiff handcuffing the parents occurred? And so, because it had not occurred, and yet the implications of what it means to have your work record altered like that at the time had her say, her response was she did not have a recollection of that event, which would not be factually incorrect if it had not actually happened. Or was it the kind of thing where more than once or on more than one occasion, there was the experience of someone doing something within the courtroom that was against the rules of the court, and it actually did something like emit a low-level radio frequency that actually triggered some form of implication that actually sequentially resulted in her not remembering in the moment, i.e., was she subjected to use of directed energy weapons even at a low level in her own courtroom in such a manner that it impacted her memory in the moment? Now, if one wants to say that there is some challenge to her professional credibility, that she would be targeted by directed energy weapons in her court, and it might cause her to forget an item in a list or series of items that is being presented, then I'd like to hear what the justification for that would be. Because my understanding is that it would be not very well served to assume that or to allow for the people that identified themselves as presenting those amicus curiae with the kind of credentials and professional experience they want to be acknowledged and credited for would not understand what the full implications are of an attorney, including one that has the kind of background that Bennett wants to be associated with and acknowledged for, would not understand the implications of refusing to follow the judge's orders and turn your cell phone off before the proceeding begins. At least understand what the potential highest level of risk in such a scenario is and make the good judgment to not take the risk of forgetting to turn your cell phone off right after you've been told directly it is not permitted to have your cell phone on in the courtroom. This is a very serious matter. This is the significant substantive matter that was behind my efforts to file a motion in the case in the summer of 2019. Because as somebody that did public relations in consideration of the effort to appeal the disbarment, and understanding as I did that it had a material impact on my efforts at due process and my efforts to represent myself pro se after I was subjected to very serious crime and not given anything close to professional consideration, that specific change in the transcript materially altered the factors of the case that Bennett was presenting, as well as what happened in connection with those that were responding to his appeal. And so if 1,000 lawyers can sign on, and then the lawyer they sign on to support knowingly and willingly defrauds the court by allowing for an altered transcript to slander the judge of concern in front of other judges, this sets a very harrowing precedent for anybody else attempting to either hold accountable lawyers or judges that abuse their office or abuse their role, or what it means to be a professional yourself or attempt to engage professionally with an understanding that there's supposed to be some sort of check against abuses, including by peers, or some sort of eternal control in order to mitigate against that kind of exploitation. Altering the transcript in the case and allowing for that altered transcript to be used in an appeal through and at the Supreme Court level impacted everybody who was abused or misrepresented in that case. And so this has persisted until this time. The second factor was this understanding of the characterization that, again, second time, there is a declaration that it's about a transcript regarding not having a signature on. Not so ironically, in the summer 2017, I was an expert witness in a case where somebody I was an expert witness for and was supporting, who was representing herself pro se, had been subjected to an alleged order by a judge that had not signed the order. And upon the appeal, there were numerous problems and numerous violations of judicial ethics, not to mention actual procedure, that had not only a material impact on the woman in the case at the time, but have had serious long-term, far-reaching consequences. And when an effort was made to attempt to remonstrate before the Supreme Court of Texas to address the potential criminal implications of what that specific order and the lack of signature meant in a context of other violations that had been committed by the attorneys involved, well, we are where we are now. So the question becomes, is that the truth? At the time this occurred, was there actually a transcript at the time in a case that was more recent to 2014, where Kelsey did not put her signature? It says the transcript states Kelsey told the officer he would have to go to the Behar County Jail to get the signature. Because in order for there to be a release from the juvenile detention center, there had to be a signature. So this lets you know the judge understands certain things are not legally binding without the signature. Was this something that was used in a manner to attempt to discredit her as some form of executable option that was applied later by judges in other cases? That's part of the concern at hand here. And this is part of the matter at hand as well. In light of the fact that the Supreme Court of Texas permitted for an altered transcript to be presented as a legitimate part of the evidence in consideration of an appeal regarding the disbarment of a member of the State Bar of Texas before a judge who was also a member of the State Bar of Texas, brings up very serious implications, not only in that case, but in other cases that are impacted as a result. And so this has persisted until this time. And this is something that it needs to be addressed. This is one of the major reasons why I requested a new trial in my own case that was itself sabotaged in the course of me attempting to get due process for things that happened to me based upon its abuse and abuse of my efforts in order to aid and abet crime. Actual crime. I contend that we're not talking just about a civil matter, and we're not even just talking about procedural matters that may be indicative of some sort of potential disciplinary action or a need for disciplinary action in regard to professional misconduct. I believe and understand and also believe I have evidence that can be presented to prove this is part of a premeditated strategy that is an abuse of the judicial branch of government and is actually using the judicial branch in order to aid and abet acts of crime. And so the implications are very significant and very severe, which also brings up the question of something comparable in this case that is materially connected to my own. I have never met Judge Carmen Kelsey. At the time I first was exposed to her, it was in a role where I was critical of her, with an understanding that she had been accused of professional misconduct and that there were certain implications. But after myself being subjected to the treatment I was subjected to, and also in consideration of evidence that became available as proceedings persisted, I contend that there was foul play. And then the question becomes, well, what is the extent and what is the level and what is the motivation behind this foul play? Because now I understand I am a witness to efforts to defame and slander her. And as is presented on the public record and as was understood by a number of lawyers and judges that signed those amicus curiae, we're not just talking about her as a judge. We're talking about the people that were impacted by her performance as a judge. And to be critical of her for reasons concerning potential abuse of the bench, where there were other accusations that were levied against her at the time, including she had a specific relationship to a particular process that had to do with granting of cases or assignment of cases, and that it was understood or she had been accused of being disproportionately advantaged in that system. That it's not presented in this article, but at the time that I was first encountering this case, that was one of the charges. However, that charge is not readily accessible or available online, which doesn't mean that it's not still in the original publication where I encountered it. But at the same time, what is still available online, I believe, has exposed or is complementary to a concern that evidence has actually come up that reveals what I understand to be intentional sabotage and defamation of her in consideration of altering the actual court transcript. How many cases of Judge Kelsey's had altered transcripts? We're talking about juvenile offenders, some of whom were on trial for capital charges. The implications of this are absolutely alarming, especially if it was intentionally contrived and allowed to be legitimized because somebody had an ulterior political motive. And that's exactly what I understand is happening. So at this point, I'm making an official acknowledgement of this. This trial is on the record. It has been presented in the public. It has had several appeals that have been allowed to go through. And in the course of doing that, there's been a specific perspective that has been presented. Does Judge Kelsey have any legal representation at this time? Or has she been disappeared?